recently there was a rash of U.S. Supreme Court decisions. You may have heard about some of those in the news. The Defense of Marriage Act, the challenge against California's ballot measure Proposition 8, and even the voting rights case, the Alabama versus Holder. One you may not have heard about, but which was probably the biggest property rights case in a decade, was rendered by the U.S. Supreme Court in a favorable decision to property rights owners, and that was the Kountze versus the St. Johns River Water Management District. My name is Scott Roberts. I'm the Citizen Action Network Director with the Freedom Foundation. We're a nonprofit, nonpartisan think tank based in Olympia, Washington. And one of our arenas is property rights. And here with me is Glenn Morgan, the Property Rights Director with the Freedom Foundation. And here to help us unpack the Kountze case from the Pacific Legal Foundation is Brian Hodges, the managing attorney with the Pacific Northwest Center, and Daniel Heimbaugh, staff attorney with the Pacific Northwest Center, the Pacific Legal Foundation. So thank you guys very much for coming here, and thank you to theCouv.com for allowing us the studio space today. So well, let's kick it off with a softball question for you, Daniel, and that's, who is the Pacific Legal Foundation? What do you guys do, and what areas do you normally practice in?
Sure, Scott. Thanks for having us today. The Pacific Legal Foundation is the nation's oldest and most experienced public interest legal group litigating for limited government across the country. And one of the main areas that we litigate in is property rights, which is why we took a great interest and ended up litigating the Kountze case all the way to the U.S. Supreme Court.
And in that court case, Brian Hodges, you were there. You were on the team that helped to argue this case. Tell us a little bit about what was that? I mean, that has to be a high point for an attorney, actually, to go to the U.S. Supreme Court, be there. Is it only downhill from here for you in your career, or is what?
Well, I'm hoping that I can first chair a case before the U.S. Supreme Court. But yes, it is a capstone on your career. Many people don't get the opportunity. Very few cases are actually granted by the U.S. Supreme Court, even though there are many cases that warrant Supreme Court review. So we were very grateful that they took review of this case, and even more grateful that they resolved it in our favor.
I find this case, as I've read through and done a little bit of my own research, I find some things very fascinating about it. One is how long the case has taken. I think it started with you back in '93 or '94, and finally was resolved. So almost 20 years, 19 years to get this case done. Why don't you walk us through a little bit some of the key points, or the high points, or why don't you walk the viewers through this case a little bit to frame what this issue was really about?
Yeah, well, the case is about a constitutional doctrine that prevents the government from coercing property owners into giving up their rights in exchange for a development permit. And let me flesh out the facts of the case so that we can really understand how this doctrine works. Coy Kountze Sr. Purchased a tract about just shy of 15 acres, 14-something acres of commercial property at the intersection of two major highways in Orlando, Florida, back in the 70s. In 1990, in the early 90s, he filed a permit with St. Johns River Water Management District, which was an agency that issued permits for property within this area that on properties that had wetlands associated with the St. John River. The St. John River Water Management District, I'll just call them the district from here on out so that I don't have to stumble over their name.
Sure.
They said, sure, we'll let you clear out your property, but only one tiny portion. If you give us over 11 acres of your own property, preserve that as a conservation area. He was allowed to develop on about 3.5 acres. And in addition, go onto our property, district property, miles away from the project, and do improvements, clean out some and replace some non-functioning culverts, etc., clean out ditches, restore our property to a pristine wetland. Well, Mr. Kountze thought that the demand for his own property was enough. Putting over 11 acres into a conservation easement was more than enough to mitigate for any impacts that could come from him clearing the 3 acres. And let me reiterate, this was not a pristine wetland. This is the intersection of 2 major freeways. The property, just so that you get an idea of the area, next door is a gas station. There's a dry cleaner. Across the street is doggy daycare. This is not what you think of when you think of a Florida wetland. There are no alligators. So Mr. Koontz objected and said, I don't think that additional offsite mitigation is necessary.
Now, what was this additional offset mechanism? Because this mechanism of mitigating on your own property is fairly common. You have to do buffers. You have to do conservation set-asides. There's all these kinds of things when you're doing land development. You do. The line was drawn when he had to do something off-site, down the road, unrelated to his property. What did that look like? I mean, was that just a $100 bill or was it a $100,000 bill? I mean, what was the size of this offsite mitigation he was talking about?
Well, that was one of the problems, is when the demand was made, nobody knew. I mean, the district just went to a manual and said, well, we think that 50 acres of offsite development will make up for any possible impacts. They hadn't gone on his property and said, there is a marsh here that's providing habitat for some species that we want to protect. It was just the fact that his property was designated in this wetland zone. It was called, basically calling it a critical area, presumes that it's providing some sort of function to the environment. Nobody had gone on the property and said, yes, indeed, this is here. He had to sue for that to happen. Nobody had even gone out to the district property and said, well, this 50-acre lot is going to cost $150,000 to restore or $10,000 to restore. The demand was made. He had to sue to find out even how much money it would cost, or he had to challenge the condition to find out how much money it would have cost for him to agree. This is common. That's the problem. This is common. These kinds of demands are made all the time on property owners. The only thing that made this different is that Mr. Koontz objected. So he goes to trial in Florida. This is back in the 90s.
Wow.
They have a full trial, put on experts, and they find that the property they wanted to develop really had zero critical habitat on it. The only critters that they found were raccoons, a turtle. There were homeless camps on the property. It wasn't a pristine environmental wetland that needed to be preserved. It had been drained by a city drainage ditch that was meant to divert stormwater off of the highway. Right next to it, there was a high power power line cutting through the property. So the trial court, after hearing evidence, said, no, this goes too far. Which brings me to the legal issue in this case, which was back in 1987, Pacific Legal Foundation took a case, Nolan v. California Coastal Commission, to the U.S. Supreme Court and established what's often called the nexus rule, the Nolan rule. What it's referred to as the exactions taking cases. What it says is that when government places a condition on a development permit, it can't use its power to approve or deny the condition in order to extort out of you your property. So it can't say, yes, you can build your deck or you can build your new home, but only if you give us half of your land. The issue in Nolan was a owner of a dilapidated bungalow on the California coast wanted to remodel the house to be more in line with the homes neighboring it, and the California Coastal Commission says, sure, we'll let you do that, but you have to give us a strip across the front of your beach. Mm-hmm. Well, the Supreme Court called that an out-and-out plan of extortion, said that there needs to be some reasonable relationship, what they called an essential nexus between the demanded exaction and the proposed development. Found it didn't exist in Nolan and said it was invalid. Well, we argued in Koontz, that relationship didn't exist between what Mr. Koontz wanted to do on his property to prepare it for development and some wetlands owned by the district miles away, 7 miles away, 4 miles away. There was absolutely no relationship.
So that nexus did not exist. I mean, the things that he would have had it done on his property, maybe they can make a case for a nexus with his project, but what was offsite, no way, no how. It was totally not connected, and they said that was a violation of the Nolan decision.
Yes.
It was a couple decades before. Well, at that point, it would have been a fairly recent decision, I guess.
Well, at that point, actually, the nexus question returned to the Supreme Court in '92 in the case Dolan v. City of Tigard, and in that case, the Supreme Court sort of clarified the nexus rule and added the proportionality prong to it, and said not only do you have to show that there's an essential nexus between the demanded exaction and the proposed development, but if that relationship exists, it also has to be proportional to the impact. So the district's demand on Mr. Koontz didn't satisfy either, because not only was there no relationship between the proposed use of his land and the demand that he do significant off-site mitigation, which was determined to be anywhere up to $150,000 worth of work on government property, but also it would have been completely disproportionate to any impacts that could have occurred on his land.
Yeah, if you're a local government agency and you don't want development, right, or you see or if you want projects done, you see a rich developer coming along, you say, hey, we've got all these projects we want done. Suddenly, it's like you can dig into the pockets of those guys to make you do it, and probably in a lot of cases, instead of fighting on principles or for the right thing, I would imagine a lot of property owners or developers go along, maybe not with large things, but with small extortions all along the way, and that's probably fairly common. It's probably uncommon to have somebody like Mr. Koontz stand up and actually fight for his right to do what he wants with his property, without being extorted. Yes, without that extortion. So what happens? So he goes to local courts and sues the water district, says this is unfair.
Yeah, basically he says, okay, we've got these cases, Nolan and Dolan. They require nexus and proportionality. You've basically demanded that I pay up to $150,000 to restore your property in order to get the basic, these are just clearing and grading permits that he was looking for. Right. The most basic permits, the very first step of development. Mm-hmm. So he took them to trial court and won. It took, almost 10 years at the trial courts to get a final judgment. That got appealed up to the Court of Appeals, which affirmed, said that this was both disproportionate and unrelated to his proposed development. But then the district appealed to the Florida Supreme Court, and this is where it gets interesting. The Florida Supreme Court ruled against Mr. Koontz on 2 grounds. First, it said that when government denies a permit on the ground that the property owner objected to a condition that would violate Nolan and Dolan if applied, the condition actually never took effect, therefore there's no constitutional violation. To put this in clearer terms, it's basically like saying that if I hold a gun to your head and say, give me your money, you don't give me the money, no crime was committed. That was the rule that the Florida Supreme Court adopted. Second, they said, well, money's not the same thing as property. So in that mugging example, if I held the gun to your head and said, give me your land, that would be a constitutional violation. But if I said, give me your money, no problem.
Right.
On those 2 issues, PLF petitioned the U.S. Supreme Court for review. And the Supreme Court accepted review, and on the first question as to whether you can raise a Nolan and Dolan claim when a permit's denied because of an objection to an exaction, we actually got a 9-0 victory. All 9 justices agreed with us on that. Okay. That yes, that you can bring a case based on that. It was the question of money where the court split. And we got a 5-4 victory on that, with Justice Alito writing for the majority saying that yes, money is obviously property and therefore is protected by the takings clause just like any other property.
Wow. Yeah, interesting. So I don't know if we've gone over this, but the original plaintiff, Mr. Kuntz, passed away partway into this.
Yes.
And what year was that? He started in '94, but
Yeah, I believe it was 2000.
around 2000
Yes.
he passed away. And then his son,
Coy
Coy
Kuntz
Kuntz Jr.,
Yes.
was able to continue on with the case, and then for the next 12 or 13 years,
Yes.
he fought this case. So that sounds to me like a lot of legal bills that they had probably racked up. I know you guys did your portion pro bono at the U.S. Supreme Court, but he has racked up legal bills along the way. When a property owner finally wins, I mean, this was a huge win for people all over the country on a property rights principle-based issue. What does the property owner? Does the property owner get money back to pay for those? I mean, how does that work? I don't need to know any specific numbers. Do they get their money back for all this legal battles for the last 19 years or so, or?
That depends. It depends on what statute, what laws the case was brought under, and in what state it was brought under. Luckily, in this case, Mr. Kuntz's claims were brought under a Florida statute that will provide attorney's fees if the case is affirmed on remand.
Okay. So it's just attorney fees, whatever he can.
Oh, and damages as well.
Okay, and
Yes.
damages.
He was the trial court issued a judgment in his favor at the end of basically a 10-year trial because they had the district tried to appeal the decision 4 times throughout the proceedings, which really delayed him getting a final judgment. But at the end of the day, he got a judgment of approximately $350,000 for the value of his property during the 10-year period that the district refused to issue permits because he wouldn't do off-site mitigation.
Okay.
And in addition to that, he got permits from the district to use his property.
So let's go just real quickly as part of framing this issue. The Fifth Amendment of the U.S. Constitution, I won't read the whole thing, but the last part of it says, nor shall private property be taken for public use without just compensation. That's the takings piece.
Yes.
And this case did 2 things. It said, number 1, money is indeed private property, cannot be taken for public use. And number 2, it said, any conditions of a permit must be linked or have a nexus, right, to the actual proposed project. Is that a fair outcome statement of the big issues on this case?
Yes.
Okay. So now let's move into, so what does this mean, right?
Mm-hmm.
So what does this mean for property owners? What does this mean for people going to get permits? And what does this mean for Washington State? I mean, why should property owners really care about this, obscured by the mainstream media case, let's say?
Well, if you think about the permitting process and you're a property owner and you enjoy a constitutional right to use your property. Everybody enjoys that right. But in order to exercise that right, sometimes you've got to go to the government to get a permit in order to do that. Well, that creates a situation where you've got the government that has the authority to approve or deny your permit application. And you can't exercise your right to use your property until you've gone through that process and gotten your application. So in a constitutionally acceptable situation, you might have to pay an application fee. They process your permit. Perhaps there's something about your development that related to public health and safety that the government wants you to address. But you meet all the criteria, you're good to go. In a situation like Kuntz and a lot of these other exactions cases, you've got a situation where the government is acting opportunistically. They're waiting for the permit applicant to come along because they know that that person can't use their property unless they're given permission to do so. And so it becomes a situation where you've got a bureaucrat in the planning department trying to determine just how much property or money we can squeeze out of this person before we'll let them go forward with their development. So in general, you alluded to this earlier, a lot of property owners would say, the permit is actually, getting the permit is worth more to me than having to engage in all of these conditions that I don't really think apply to my property. But I'm going to do it anyway because it's a business decision. So generally, what Koontz does is it says there are indeed constitutional limits to what the planning department can do to you in that situation. We've known that it applies in situations where the government wanted to get a dedication of land from you. What we now know is that it also applies in situations where the planning department wants you to pay a certain amount of money or a fee, perhaps a mitigation fee or an impact fee. It was unclear before Koontz whether the Constitution applied in that situation and how. Now, we at PLF have argued many cases where we've said, of course it applies, for the very same reasons that we argued in Koontz. Now we've got the U.S. Supreme Court agreeing with us on that point. And I think all property owners should actually be really excited about that. Being a part of the property rights movement, sometimes you're looking for small victories where you can get them because property is so intensely regulated at all levels of government, even though it's a foundational right in the Constitution. Koontz is a major victory for property owners, and in Washington it's going to apply with just as much force here as it would in Florida because
Right.
it's a U.S. Supreme Court case.
So then that brings me to a question I have, Daniel. That you and I both deal with property owners all
Right.
around Washington State with frequent conflicts and problems they have with local government and regulatory overreach and challenges. So if we were to provide recommendation to other property rights activists and people that are involved in their community on these issues, it would be based on what I'm hearing here that you should go to your local government and your local plan department and bring this information from this case and tell them that they need to review their rules just from a constitutional standpoint that apply to mitigation or buffers or impact fees or things like that. Because it's very possible, and in fact probably fairly likely, that many of them are in violation of what the Supreme Court's ruling has. Am I representing that correctly?
I think you are. I think there are really
Okay.
two things that property owners and property activists and other people who are interested in these issues should do at this point. One is understand that Koontz makes it clear in very direct language that these constitutional limitations apply in situations where you've got mitigation fees, etc. Local governments may have permitting processes that are ongoing, that are pending, and now that Koontz has come in, it's really their duty to look at that and make sure that they're not violating the Constitution as interpreted by the Koontz opinion. But I think even more important going forward is property rights activists and property owners have an opportunity now, because in Washington, local governments are required by law to update their land use regulations on a pretty regular basis, which means that they've got to make sure that when they update them, one of the things they need to look at is, do these regulations still comply with all of the legal developments that have occurred since we first put these into place? Koontz is going to be a very important opinion for the property owners and the planners to understand. In a way, it provides a lot more guidance for planners so that they can make sure the regulations are written in a way that will avoid the kinds of situations that Mr. Koontz found himself in and that others in our state have found themselves in. So it's really something that I think property owners should be aware of and make sure the local government is also aware of it too.
Now I know you guys, this is the kind of question that attorneys don't like. But at what point along the scale does that nexus and proportionality balance? I mean, I think most people can see that the Koontz case, this mitigation, miles off-site, didn't have any nexus or proportionality to his particular proposed project. But on the other hand, people can see if you're doing a development in town and you're changing a 5-acre piece into 50 lots, that you're going to increase some traffic and there's going to be some traffic mitigation. They're going to have to improve some roads. Some projects might have to improve a couple blocks of road. Some projects might have to, improve 20 miles of road. So at what point in here does this case start to creep in, or is it going to make more challenges down the road to really try to pull in that nexus and proportionality piece? I mean, at what point do we get where the threshold, let's say, can go to zero, right? From miles away to anything off your site. I mean, is this
Well, I think the beauty of the Kuntz decision is that it's actually very balanced. The court recognized that, yeah, the land use permitting process can be coercive, and the Constitution protects property owners from that. But it also recognized that the local government does, in our modern land use system, have a role to play. The beauty of the decision is that it requires the government to show on a case-by-case basis that what they're doing is actually within the bounds of the Constitution. So, it's going to be an individualized determination in most cases, but what property owners can do now that we have the Kuntz decision is rest assured that there are constitutional limits that are going to be enforced against governments that go too far.
There's starting to be a better framework
Yes.
around those issues.
Yes.
And that's where, you really get into these property rights cases. They're fact heavy, right? They're very specific to this individual, this project. And it really takes somebody with the courage like Kuntz to say, my project, I'm going to fight for it. I think of all the things when I look at this case, I think of how much of a hero that Mr. Kuntz was to actually start down the road and fight against really what was City Hall at the time. It brings in other questions like, and you guys do a lot of, Pacific Legal Foundation does a lot of endangered species litigation, and there is a lot of mitigation, right? So the pocket gopher thing we had down in Thurston County, somebody starts to develop their project, they say, you've got pocket gopher habitat. You have to go replace that pocket gopher habitat with, you're destroying 5 acres, you have to go find 5 acres somewhere else in the world. And that could be 20 miles away or 30 miles away to mitigate that. So it's not just the distance, it's the relationship to the project. But will this creep into endangered species mitigation in some ways, potentially? Or
Well, you point out that every case is fact intensive. That's always going to be the case. But and maybe Brian, you want to chime in on this too. I think theoretically there's no reason that Kuntz couldn't apply to a situation like that, where you've got a condition that's being applied. In an ESA case, it'd usually be for mitigation. The court was very intent on making sure that property owners who are, in the court's words, especially vulnerable in the permitting process are protected. And so I think you could see that these sorts of principles start to come into play in all kinds of different permitting situations.
And I think what's significant, to follow up on Daniel's point, what's significant about Kuntz is that it confirms that the burden is on the government to show the nexus and the proportionality. If it's going to demand that, say, you need to preserve 5 acres of property for whatever reason, first it has to show that it's necessary based on the impacts, but it's also going to have to show if it's a 5-acre conservation off-site, that is proportional to the impacts on your property. That rule really flips the field on ordinary government practice, which is to say that we're just going to presume because there's a gopher on your property or because of your proximity to a stream, et cetera, that you're going to have this panoply of impacts on the environment or on gophers or on traffic. And based on that presumption, we're going to require you to do X, pay impact fees or purchase property in a mitigation farm, et cetera. Those days should be over after Kuntz. They should have been over after Nolan.
Right.
But there was enough confusion about how Nolan would apply and when Nolan would apply that the government was able to get away with it for 35 years and increasingly carve out exceptions like doing in lieu fees or mitigation banks.
Something about this case that really struck me, and I was looking at the video that the Pacific Legal Foundation put out about this originally before the case was decided. You're interviewing Mr. Kuntz, and one of the stories that he had was getting into the elevator after one of the hearings, and with some of the district attorneys as well, so some attorneys on the side, and the people from that district, and saying, well, why don't you just buy my land, with all this expense? And they said, I was struck by at least the way he described it. They said, well, why would we buy it when we can just get it for free? And that arrogance that I think the Kuntz case reflected on the other side is something that we see all over Washington State with local jurisdictions on these issues. So I think that was something that really struck me as being, these are your modern planners. This is how they think. And this case, I hope, will start to control some of that behavior.
I think that's true, and I think what Kuntz reflects is that the court has finally stepped in and said all of the ways you've tried to get around Nolan for all of these years, stop it. That's not going to be tolerated anymore because the principles apply, and we really are interested in protecting property owners who have constitutional rights.
Okay.
So we really are starting to rein in government, at least to create the framework that's going to rein in this at least the blatant extortion
Right.
ideas. You know, our phone rings every day at the Freedom Foundation with people that think they're being extorted by government in some way, and a lot of it's around permitting. So I'm really grateful that that you guys have took on this case and that you
Right.
prevailed in the way that you did. I think it's a big, huge win for property rights activists and property owners all over the country. And I think we'll start to see impacts here in Washington State as we move forward. Of course, time will tell, right?
Absolutely.
Yeah.
But you guys will be here to help litigate every step along the way when government starts to encroach onto individual rights. So.
That's right. I'd encourage people to visit our website at pacificlegal.org to learn more about the types of cases that we're working on. We also have a blog where the attorneys will kind of go into a little bit more detail about the issues and cases. And just a reminder that in Kuntz, like all of the other cases that PLF works on, we represent clients pro bono. And the reason we do that is because it takes an enormous amount of resources to fight the government, and we think that it's an important enough project that we've stepped in to do that.
Yeah, I was very impressed with how you brought a team of attorneys from all corners of the United States together with Pacific Legal to work on this case, which is a real testament to your strength. There. Is there any other questions that you think we should address? Or?
For people who want to support the Pacific Legal Foundation, they just go to your website and.
Best place to go would be pacificlegal.org. That's
Okay.
our website. They can learn how to support us there, and like I said, read about our work and get in touch with our attorneys. And like you mentioned in the beginning, Brian and I work in the Pacific Northwest Center in Bellevue.
And I guess with that, anybody who, the Freedom Foundation, you can go to myfreedomfoundation.com, and you can also find out what the Freedom Foundation is doing about property rights all around Washington State. And if you think you have a case where you live, where your government is violating their planning department's violating these types of issues, please feel free to contact us at the Freedom Foundation.
Well, on behalf of the Freedom Foundation, we'd like to thank the Pacific Legal Foundation, and a special thank you to theCUV.com for the use of the studio today in talking about this important property rights case.